Hello, Professor and Miss Skiba. This is my presentation for my Lib Guide entitled Advertising and the Law. On the first page, the home page, there's the graphic that I created that has advertising and the law. Below it is the overview, and the overview just says this Lib Guide is a research tool intended to provide useful data to help answer questions and address issues that may arise regarding advertisements and other forms of commercial speech. Advertising is one of the handful of areas that has been increasingly scrutinized and regulated in traditional platforms, but has more recently functioned as a trailblazer on the digital frontier of the internet. Online advertising has become the sole vehicle to enable the high tech pioneers entrepreneur to access financing. This guide will provide information about both the laws governing the traditional older platforms as well as the seemingly lawless Wild West digital mediums as well. So the first page is pretty straightforward. I have the Wild West graphic. I have a picture of me as the author. To the right, there's the disclaimer. Now moving to the second tab, Introduction. For the Introduction tab, I decided to make my own video to explain to the users how to use this LibGuide and what this LibGuide will discuss. So I embedded it into this page. Otherwise, if you click on the top image, it will take you to YouTube, or you can watch it in YouTube. Otherwise, uh, you can watch it in the page. So we'll do that now.
Commercials, advertisements, marketers, and their ilk are everywhere these days. We see them when we check our emails, we hear them when we turn our radios on in the car, we see them on billboards and websites and social media, and seemingly any conceivable place where a marketer could send a message and be seen by some form of humanity. But what sort of laws govern these messages? Obviously, there's some law that covers these messages. We know that because of those disclaimers that are used at the end of the commercials, where the voiceover comes over and it sounds like the guy at the in the old Micro Machines commercials.
Aircraft carrier playset. The dramatically scaled, truthfully trim replica of the real thing that holds 25 Micro Machines with fabulous, fantastic features, two totally terrific elevators, real working hoist, runway, and two cargo arms. The new Micro Machine aircraft carrier playset from the Lib. Remember, if it doesn't say Micro Machines, it's not the real thing.
This Lib Guide is designed to provide information about laws that govern and pertain to advertising, address and highlight common and potential legal issues that can and may arise in the general course of executing a marketing strategy, and provide information, data, suggestions on where to turn to answer specific issues not covered directly by this Lib Guide. The first tab, labeled Issues, discusses the many issues that arise in advertising law. Just to name a few, these issues include free speech and First Amendment issues, copyright, trademark, infringement, contracts governed by both the common law and the UCC, torts such as defamation, slander, libel, as well as products liability, just to name a few, not to mention ethical and legal considerations in advertising to minors, advertisements for vice such as alcohol, tobacco, gambling, and now in some states, quasi-illegal substances such as marijuana, but also legal pharmaceutical drugs, and of course, the most contentious form of advertising, political campaigns. On the other tabs, you will find information about sources and other research features designed to provide more in-depth information on a particular research method or topic.
All right. So that was the introduction video, and that just kind of provides a general overview of the entire Lib Guide, which I thought was a unique way to start the Lib Guide. The next tab is Issues. So the first page of the Issues tab talks about how many of the issues pertaining to advertising span across the different platforms, and how in the first tab, the general tab, we'll discuss the issues that kind of span the gamut of the different platforms. And then in each of the main platforms that I focused on, there's television, radio, online. And the more research I did, the more I realized that this topic area was just vast. And it, I didn't want the LibGuide to be a mile wide and an inch deep. So, in order to uh, provide more uh, detailed and a more in depth uh, amount of research, I had to kind of hone in on the three main platforms that are used. So, under the general tab, it mentions the different issues, and these are just a general overlay of the issues. So there's constitutional issues, as I mentioned, free speech, commercial speech, lies, obscenity, intellectual property issues, of course, with copyright, trademark, unlicensed, unauthorized license and usage, ethical issues, antitrust issues, contract issues, professional responsibility issues. Then there's local and state issues like zoning ordinances, traffic issues, and laws. That would pertain to like the billboards that I don't really focus on too much in this lib guide. There's also political advertising and torts. The third tab, or the second tab under issues, is television. So in this tab, what I did was I focused on the limits on television advertising. And as you can see, here's a quote from Mark Twain. Really, I think the nub of the law of advertising on television boils down to this second sentence under the Mark Twain quote. Advertisers are prohibited from using content that is too sexually explicit and obscene words and gestures. That's pretty much the limits there is on TV. And you think that'd be easy, but advertisers and broadcasters really alike, they're both pushing the limits. I mean, as anyone who's ever turned on TV in the last 20 years, they're not allowed to use foul language and indecent or yeah, nudity in the broadcasting, and they really walk right up to the edge of the to the cliff on those issues. So I then address the different things that are banned from TV. The first one's profanity, and it mentions about the fine if you use an expletive on TV is about $30,000. So it's a pretty hefty fine if you are found guilty of using something that is considered an expletive on TV. And then there's the FCC definition of profanity. Profane language includes those words that are so highly offensive that their mere utterance in the context presented may, in legal terms, amount to a nuisance. So the only word that's really mentioned in the regs is they don't use the word. They call it the F word, but we all know what that is. And but words that invoke the same sort of feeling uh, that one would have when they hear the F word. So if it makes you feel the same way as you feel when you hear the F word, then chances are that you're dealing with an expletive, which is a really kind of a strange way of having to describe foul language, but that's the way they chose to do it. And then nudity, of course, is unacceptable. But what is nudity? Well, the regs really they're very vague on what they mention. Pretty much what they hone in on is the you're not allowed to show any genitalia, whether it be a male or female, and they also explicitly bar the use of showing a female nipple on the breast. So, obviously, a huge case where this was an issue was in the Super Bowl uh, snafu that happened with Justin Timberlake and Janet Jackson and the wardrobe supposed malfunction. That cost CBS $550,000 in fines alone. If you consider what the litigation cost, it probably cost them into the millions. So that was a pretty hefty mistake. For, as I mentioned, it was only 9/16 of 1 second. So that half a second cost them millions of dollars. Then finally, the third category that is of material that's not allowed on TV is indecency. So indecency is that final catch-all category. What is indecent? Well, again, it's very vague in the regs. They say material is indecent if in context it depicts or describes sexual or excretory organs or activities in terms patently offensive as measured by contemporary community standards for the broadcast medium. In each case, the FCC must determine whether the material describes or depicts sexual or excretory organs or activities, and if so, whether the material is patently offensive. So, what essentially the FCC has done is it has adopted the same standards that the Supreme Court has adopted, which is kind of a three-pronged test. The three-pronged test is an average person applying the contemporary community standards must find the material as a whole appeals to the prurient nature, that is having material having a tendency to execute lustful thoughts. The material must depict or describe in a patently offensive way sexual conduct specifically defined by applicable law, and the material taken as a whole must lack serious literary, artistic, political, or scientific value. So, again, the Supreme Court has indicated that this is the test to cover material such as what they called hardcore pornography. A final issue that I mentioned in my Lib Guide was a little tongue in cheek, but also, unfortunately, is something that is going to come to the forefront, and that is something I labeled as transitional issues. And what I meant by that was about transgendered individuals. And now, recently, with the recent media hype around the Bruce slash Caitlyn Jenner situation, we have these new novel issues that are going to arise because what happens where the FCC has the rules that say that a man, a men can be seen shirtless. Uh, Oops, what is this? Okay. Uh, if a man can be seen shirtless, um, then that's totally acceptable on that's totally acceptable. But what about now of the man who's becoming a woman? So Bruce Jenner, as he or she, Caitlyn, whatever that is right now, it's a person who has uh, male genitalia but kind of female looking upper torso. Well, is he allowed to go uh, shirtless on TV? Because technically, under the FCC guidelines, it would be yes, but you think that would be pretty outrageous. And then so what? How would the FCC react and rule on that? We'll probably see that in the future. It sounds bizarre, but it will definitely. I mean, we can almost be assured that they're going to. This issue is going to come up in some, if maybe not in advertising, definitely in the broadcast TV context. So and I mentioned other things, and this is, like I said, tongue in cheek, but, what if instead, it wasn't a person being, transgendering? What some guy who just got breast implants, on a dare or to be funny or something like that, and they say, well, no, that would be unacceptable because you're showing breasts on TV. Well, if you go down that road, what, at that point you'd say, well, what about larger men whose pectoral area looks more like a woman's breast? So, are they going to ban big guys from being shirtless on TV? And you see how it can kind of get ridiculous. So, look to the future. You can almost bet that there's going to be issues about uh, the about what sort of uh, content can be put on TV. Uh, Nudity is a very very common issue that is litigated in the courts, and marketers and broadcasters alike are seem very intent on pushing the line as far as nudity. And the other important thing I'm going to mention about both TV and radio is that the FCC standards are the most strict from 6 a.m. till 10 p.m. After 10 p.m., they loosen the standards. The standard is a little more lax, and they are not as concerned with having these um, more strict standards. So that's why if you ever watch TV late at night, you'll see that some of the commercials and even some of the television shows, to be honest, they start discussing more risque material, and you might see something that's a little more indecent. Well, they're allowed to do that because the thought behind that is the FCC has these standards to protect children, and children should not be, up past 10 p.m., I guess. So that's the thought behind that regulation. The next tab is radio. Now, radio is very similar to TV. Again, no obscene broadcast. That means no profane language, no indecent language. Obviously, there can't be uh, nudity on the radio other than psychological nudity, I guess. But really, there's no. They just can't discuss inappropriate topics. Uh, and they would be under the same sort of context as TV, except in just an audio platform. And again, another thing to mention about both radio and TV is that they don't apply to subscription services. So, XM radio, Sirius radio, even cable television, especially the premium channels, Showtime, HBO, Cinemax, and other video and radio platforms like that. They don't apply because those are not governed by the FCC. So, excuse me. Um, and I also included some important historical facts that I found interesting after doing all the research about why the airwaves, they're governed by the government. They're and what they do is they give licenses to different stations and radio stations and TV stations, and that's why the government is allowed to police the kinds of content that they have uh, on their networks. So, and that's been this way since 1929, when President Herbert Hoover was before he was president, served as Secretary of Commerce. And what happened was people were using the same frequencies in radio because all you had to do to get a radio station was to send a postcard to the Secretary of Commerce. What happened was people were getting radio stations with the same frequencies, and they were basically broadcasting over one another. And to help alleviate this issue, they tightened up the standards and organized it a little more so people weren't tripping over each other's toes. So the final issues tab is online. And this one is short, and that's for a reason because the online regulations are there just aren't a lot of them. Uh, obviously there's lots of places that we get marketed to nowadays: Facebook's, Twitter, YouTube, uh, all websites we go to, our emails, and many of those platforms are actually just covered by ordinary law. So copyright law, a lot of it also includes the online um, platform as well. And what they did was they just simply went in to the many of the copyright laws, and they just amended them. This is probably 10, 15 years ago, and they've been doing it every time they see a regulation that doesn't include the internet or online. They just simply amend the legislation and then adopt it, and it's usually easily passed. So many of the same laws apply to the online platform, especially in trademark, which is one of the biggest concerns for content providers. Uh, and those are the areas where people are. There's a lot of violations. People using other people's material without their permission. So the truth is, in that it's also very difficult for legislatures to keep up with technology. They're always, several steps behind technology. And what happens, like I mentioned, the anti-spam and pop-up blockers, was Congress was very concerned about spam and other intrusive types of marketing, and the and so the government, the legislatures kept talking about, what kind of bill they wanted to make with the anti-spam. Well, in the meantime, the public was fed up with getting these spam emails, getting pop-ups. So the private sector, what they did was they just developed pop-up blockers and anti-spam software, and people just bought that or used that, and that kind of solved the issue. So when Congress finally got around to passing legislation banning spam or regulating spam, it's kind of a moot point. So you'll see that a lot with a lot of the online marketing issues, is that the private sector really does a pretty good job of regulating itself. Um, and there's certain areas, and we all know, of things that are horrible that are on the internet that we're thankful that the government tries to take care of, protecting children and stuff like that. So, uh, but as far as advertising marketing, a lot of times those issues are self-correcting as they develop, and and the private sector does a great job of correcting those. Moving on to secondary sources. So this is where I started my research, and secondary sources were a godsend. As I mentioned in some of my discussion board posts, I think this was the area of law that I did not, or these were the resources that I ignored when I first came to law school, and I really did myself a disservice because I was so focused on getting the right cases and the right primary sources that I thought the secondary sources would slow me down in my research. However, I couldn't have been more wrong. And the secondary sources actually lead you to the primary sources that are the most relevant to the topic that you're addressing. And if I could go back and, give myself advice, as a 1L student, I would say you don't have the you don't have the time not to do the secondary sources. Not that you should, bypass the secondary sources step. Uh, you're going to waste way more time just jumping into the primary sources and drowning in the amount of content. So I was the secondary sources. I liked them so much that it was hard to peel myself away from the secondary sources. I'd find one, and then another secondary source would lead me to another one, and I was just learning so much about advertising law as I started my research, and then I realized how broad of an area it was. And I thought I should have probably focused more on specific aspects. But I'm glad I did it because I really learned a lot about advertising law, and this would be a really very interesting topic to handle in real life. And I hope I really get the chance to do that at some point in my career. So it's one of the first places I actually started was the law blogs, and I did that because of the uh, the section that we, I think it was the third week of class, where we talked about excuse me, secondary sources, and for topics that are um, more recent. So advertising law, even though advertising's been around for probably centuries, but this type of law is sort of new. So I thought maybe going to the blogs would be a good place to start for this type of um, for this type of law. And so I started with the law blogs. The best one that I found was this one from the American Bar Association called uh, All About Advertising Law. And this one had lots of information from top attorneys across the country about issues that they have with different advertising concerns, from digital to uh, print ads to television to radio, the different things that businesses come and hire attorneys to ask them, how they can either be shielded from liability, or when a complaint is filed against them, seeing if they somehow had any made any sort of violation in their advertising campaign or anything like that. So it had a ton of great issues, and it gave me lots of great ideas and kind of pointed me in the right direction. It was a good place to start, uh, and I was just really pumped up to after reading a lot of the articles on that. Another good one was SCOTUS blog, and that one I actually looked at for one of the cases, and that was the FCC versus Fox, and that regarded an incident where Cher at a Golden Globes award used, I think, the F word and the S word, and it was on live broadcasting. And there's this issue called the fleeting expletive rule, basically, in the regulations, where broadcasters wouldn't be held liable when something happened on live TV, and someone, a celebrity or whoever, comes on and yells an expletive, that they shouldn't be held liable for that. And actually what happened there was the fleeting expletive rule was overruled. They said no, they still are responsible for that content, although, as I'll discuss later, really what happens with the FCC is that it's very politically driven. So under the Republicans, uh, there was a lot more heavily scrutinized. Uh, the content was a lot more heavily regulated and scrutinized. Violations were taken very seriously, as as opposed to under the Obama administration, the new uh, FCC commissioner has been a lot more lax. So he lets a lot of things fly. He doesn't really pursue violations unless they're flagrant, uh, some sort of flagrant violation that can't be ignored. And so, anyways, the fleeting expletive rule was kind of thrown out, and they said no, you're still liable. And then you'll see that that's why there's a tape delay now, or if on radio people have something called the dump button, and it's pretty much the radio version of the delay feature. So in case something crazy happens, they have a couple seconds to dump that content, so they're not in violation with the FCC. Moving on, so the American Law Reports, again, great resource to give me definitions. So when they say, what's profane, what's nudity, what's trademark infringement, what's uh, unauthorized usage, what's deceptive, these were the places that I turned to get that information and to really give me cases that illustrated what I needed to know about the different particular issues. And that's very helpful because that was how I started to form in my mind the picture of what the law was. Same thing with the American jurisprudence second. And then my favorite secondary source was the treatise uh, that I found. And I had actually never really used a treatise before. Um, in in law school ever. So this was the first one I ever really kind of looked through, and it was fantastic. It had so much information. It's written by four law school professors from around the country, and it was just wonderful. It's called the Law of Advertising, and it was just so well written, and they just keep on adding more things. Their most recent edition came out with uh, marketing and advertising on smartphones, and it was just really, it was great. In fact, if I was starting another research project on advertising, I'd highly suggest to anyone that they turn to this source first. It was just great, and it boiled down the law. You know, sometimes these statutes are really long, and you want to know how it actually works. Well, the treatise is really great because it boils out and said, you know, yeah, this 20-page law basically boils down to these 4 points. If you have these four things, you know, you're in violation, or you're not in violation. So I love the treatises, and I will definitely use those in the future. I thought that was it was just wonderful. I didn't know what I was missing. So the other two that I used were West's Federal Administrative Practice, and these had a lot of great stuff because they talked about the constitutional issues of the broadcasting, content, licensing, stuff like that. And then finally, the Federal Procedure Lawyers Edition, and these talked about censorship um, and again, they really boiled down and got to the nitty gritty about what was what kind of content you can use and what you can't. And then finally, I looked at a couple scholarly journals. This one by Mr. Goldsmith, Samet, something. Anyways, it was great. It talked more about how the FCC, kind of is selective. Like I came to this conclusion on my own, and then this article kind of confirmed it for me about how the FCC's run, and it was kind of funny because it really echoed the what we talked about in the administrative law section in this class about how the administrative regulatory agencies really have lots of power. So this, FCC commissioner gets to decide basically what we're allowed to view on network TV. It's pretty uh, substantial amount of power to wield to someone who's not even elected. He's just appointed. So I thought it was uh, very germane set of issues that we even talked about in the class. The next tab is case law. So case law, I showed my favorite case in law school, and I thought this was a great way to kick off the case law section of the Lib Guide because uh, this was just a hilarious example of a commercial on TV that in an advertising campaign where litigation came out of it. And I mean, this one is literally ridiculous. And you can just watch it and see for yourself.
Introducing the new Pepsi Stuff Catalog. Now, the more Pepsi you drink, the more great stuff you're going to get.
Sure beats the bus. Yeah, I love that ad, and in fact, that was the first case we studied in contracts my 1L year. So what happened was it said Harrier Jet. If you notice at the final frame that said Harrier Jet 7 million points, right? And this 23-year-old guy in New York saw that and said, "Oh yeah, you can purchase points for 10 cents a point." Well, so he somehow got investors, and they ended up raising a little under $1 million to buy the Pepsi points to buy the Harrier jet, and they got 7 million points. He sent them to Pepsi and said, "Hey, I have the 7 million points. I'd like my jet, please." And they said, "No, that was not. That was supposed to be funny. You shouldn't have taken that seriously." And the kid was kind of genius. I could, if it worked, I was rooting for him. I can tell you that when I read the case, I was like, I really hope he gets the jet, but he doesn't get the jet. As anyone who's read the case knows, he didn't get the jet because that was not considered a contract. That was considered just an advertising. Uh, that was just some kind of entertainment, and no, the court said no serious consumer would think that you would be able to buy a military jet by drinking, a soft drink. But there's lots of this there's many rounds of litigation that Pepsi went through uh, in this case, and I thought it was great. Um, and it was just a very, very funny case and a fun way to start the case law on advertising. The first tab under the case law is false advertising, and there are different laws governing the false advertising aspect of and different advertising. I included a graphic. This is what, Burger King, McDonald's, Taco Bell, this is what they look like on the left, in their advertisements. But then, no one's ever seen a burger like that when if they ever go to a fast food place. So, yeah, the case can be made that those are sort of false advertising. But what I did was I broke down, I used some of those secondary sources, and I broke down the false advertising law, 15 United States Code 52, and I broke it down into the different parts to explain what that law pertains to, what type of advertisements are included under the section, the probable effect, the good faith, the intent or knowledge on the part of the advertiser. And then I included, cases that and links to cases that exemplified what those different parts of the law said. I also included an important note for advertising agencies. The advertising agencies, now they're in a unique position because they get from different corporations. A corporation will contact an advertising agency, and they'll say, "Hey, can you make a marketing campaign? We have a new burger coming out, and this is what's in it, and we'd like you to make television and radio and print ads." And the market so but what if they get false information from the corporation that gives them that hires them? So advertising agencies are sometimes in a tough position because they make the ad that violates the FTC rules or the FCC rules, and so there's different concerns. And so I mentioned that, and also and those touch on antitrust issues and other more complicated facets of the law. And then it talks about damages, restitution, some of the different things that if they are found in violation of an FTC regulation or statute, what happens there. And then on the left side are cases pertaining to the falsity of advertisement. So this really focuses on what actually are false advertisements, and so has to have actual deception, the net impression. Another rule or standard is the ignorant consumer standard, and that's basically saying advertisers can't just say, you know, well, that consumer is stupid and and almost kind of like the Pepsi case, although the ignorant consumer standard worked in the advertiser's favor in that instance, but um, things that are a little less clear or a little less ridiculous, the court will give deference to the consumer, and the advertiser has to consider people who are not, the most sophisticated of consumers. And it kind of goes in, if you think about it, that also kind of applies to commercial law, in the sense of, did it form the basis of the bargain? Did that induce this person? Did the advertisement induce the person to purchase the product? And if it became a part of the basis of the bargain, well, they might have violated some, Article 4 of the UCC. So all these issues are really, really important, and they really there's an interplay between them and other laws, and advertising can touch on a great many areas of the law. So another one is the cutting through the fat, the skinny on false weight loss ads. So one of the most recent cases was this one with this ad with Kim Kardashian. I'll play it really quick.
You're one of the people who bought these Skechers shoes promising to shape up your figure. Listen to the company. I did indeed, Savannah, 2 pair. The company is sending out a total of 40 million to customers duped by its ads featuring Kim Kardashian. The payout is a result of a settlement with federal regulators who accuse the company of deceiving customers with false promises to tone their tushes. The exact amount that each customer will receive varies depending on the particular claim. And if you haven't filed your claim yet, you're out of luck. It is too late to file for a refund, but it's a reminder, buyer beware.
You get 2 checks.
I don't, because I didn't know about the refund until I just read the story.
Is it a full refund? We don't know.
Checks. Okay.
Okay, so as you can see in that one, they echo the time tested maxim of caveat emptor. And, in that case, the Federal Trade Commission announced that Skechers had to pay $40 million to people who bought shoes that thought that by wearing and walking around in these shoes that they would look like Kim Kardashian, which, you know, talk about a talk about the ignorant consumer standard. But in that case, that's what they said. They said that that these advertisements created a false impression, and they were guilty. So I break down the different things with other kind of weight loss ads, and there are other issues that come in, especially with drugs, weight loss supplements, and things like that. And so there's some cases that touch on, and they also start talking about FDA, Food and Drug Administration regulations, and other sorts of regulations that if you're marketing products for weight loss, they are probably the most heavily scrutinized uh, products, uh, product advertisements out there. Maybe second only to products that are aimed and gears toward children. The law with marketing towards children has really, really cracked down in the last 2 decades, and um, people, and the government just does not want people to prey on the most innocent in society. So the next section under case law is constitutional law issues. So basically, I talk about, every law student and attorney should begin their constitutional research quest by asking this important question: can the government do this? Well, yeah, the Supreme Court has said that according to Article 1, Section 8, Clause 3 of the United States Constitution, which we know from, if anyone's taking constitutional law, is that this is the Commerce Clause, and what they have swept into The definition of the Commerce Clause is advertising, and whether or not that is what the founders intended, that's what the Supreme Court has mandated. So advertisements are covered under the Commerce Clause. There are a few different issues. So cases with the First Amendment, most of these are First Amendment issues. The cases of the First Amendment and deception. So advertiser puts out a deceptive ad, says, well, I have freedom of speech to say, whatever I want, even if it's not true. Wrong. The Supreme Court says, no, that's commercial speech, and commercial speech is not the same as individual speech. So you don't have the right to lie to consumers, and we don't want you doing that. So you're not allowed to do that. Uh, then there's cases with the First Amendment and censorship. So these will get into more of, a lot of the issues we talked about under the television tab about what is constitutionally protected speech and what is not constitutionally protected speech. And most of those are policy driven, as we know. Commercial, non-commercial television, radio broadcasts, standards for judging obscenity. So it kind of goes back and touches on some of those issues that we talked about under the radio and television ads. Here's the fleeting or isolated material uh, issue that I talked about. The due process. Again, we talked about that. It's an administrative law thing. So, and it can always get kicked up to the federal appeals level, but it starts out in an administrative court where they file a complaint. The advertiser or broadcasting network appeals or says, goes to the court and says, no, we didn't violate. And then an administrative judge rules on it. And then the FCC or the FTC or whoever wins or loses will appeal. And then it gets kicked up into the federal court system. And it goes through the circuits. And in some circumstances, goes all the way up to the Supreme Court. So that's to make sure that they don't get denied their due process. So one of the most uh, seminal cases is the Pacifica case, the FCC versus Pacifica Foundation, and this came out in 1978, but I believe the violation happened in the early 70s. And this was involved George Carlin, the late and great comedian, and someone played about 2 o'clock in the afternoon this comedy bit about seven dirty words or filthy words that you're not allowed to say on TV or radio. Well, they played it at 2 o'clock in the afternoon. A man was driving with his son in the car when it came on. And I mean, I will not repeat the words. The words are bad that you're not that he claimed that you're not allowed to say, and I think he was right. I mean, uh, anyways, the complaint was filed, and the holding was, you know, that was not allowed. And what the radio station claimed was that this was free speech and that this was constitutionally protected. Government said, no, 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 no. This is commercial speech. You're playing this over the radio airwaves, and you're not allowed to air patently offensive, obscene expletives in the middle of the afternoon. Again, remember this happened at 2 o'clock in the afternoon, so that's between the 6 a.m. and 10 p.m. If they would have played it at midnight, it may have been a different outcome, but that's what happened in that case, and that really opened that kind of turned the tables as far as how the FCC governs content over the airwaves, and they really cracked down for many years after the Pacifica ruling. So the final issue under case law is vice, and so this is about the different forms of vice and how they're also more advertising with those are a lot more scrutinized by the government as well. So the there's gambling, there's tobacco, there's alcohol, and now I even looked up. You know, I went to a discussion by the Federal Society about what happens with advertising in marijuana in Colorado, and basically what they use there, and it was the same for Washington State, which also legalized marijuana, is that they literally just use the same standards as alcohol. So it's a very interesting way that they do this. I don't even know how they are able to how this actually operates in the real world, but it's the same as alcohol. And I don't know how either, it doesn't matter if it's marijuana or alcohol. They say that 70% of the target audience has to be 21 or older. How they measure that, I don't know. I mean, I don't obviously they can't play marijuana or alcohol ads during on Nickelodeon or something, but I don't know how they determine whether um, they hit that threshold. So 30% or less of the audience, the viewing audience, should be under 21. Again, I don't know how that works in real life, but that's the law. Alcohol does the same thing. Alcohol has to mention they have things that they have to put on the label. They have to you'll see the drink responsibly. They always say that in the commercials. Oh, this is great. This product's great, but make sure you drink responsibly. So anyways, and you can't put out, and again, you can't. They limit the places where they're allowed to market the products. They can't go to children, and mainly that's the main thing is to protect children. Same with tobacco. Tobacco, um, we've seen that happen in the last couple of years of you know. Tobacco used to be able to be advertised everywhere. You had the Joe Camel and the Marlboro Man. Um, Not really even in my life. I don't know. I think I might have remembered Joe Camel when I was like a baby or something. But pretty much my whole life, tobacco's been know persona non grata as far as on TV and on the radio. In fact, I'd say they're actually directly marketing against tobacco. So those are some developments in the law, and I'm sure and cannabis has already jumped in and is in the same sort of boat as I think alcohol and tobacco. Next is the statutes. The statutes I included were the Digital Millennium Copyright Act, the DMCA. And that reminds me, so what I try to do on some of the issues too is I present um, uh, something that happened. So like under the TV, you and your company did something naughty in your advertisement. Someone uttered a curse word or showed too much skin. So I ask a question. What happens if you have an FCC complaint? Well, then under my defenses and solutions tab, I answer the question. So with the DMCA, I asked that one under the online section of the Lib Guide. I said, you're the owner of a website, a third party someone visiting your website post content um, that is a third party post content to your website without authorization, and then the owner of the website could be found guilty of copyright infringement. But under the Digital Millennium Copyright Act, DMCA, what happens to you if you have a website, people go and they post stuff in the discussion forums. How can you protect yourself without having to monitor your discussion forum, be glued to your computer and monitor your discussion forum 24 hours a day, 7 days a week? Well, again, that's mentioned under the defense and solutions tab. There are three things you got to do. You had to designate an agent, provide notice of your agent to the copyright office, and then respond promptly to copyright complaints and claims. And this is a good faith exception to the law. So, because the copyright infringement is strict liability, it's black and white. Did you infringe or did you not? This is the way. They call it the what do they call it, the safe harbor exception. The safe harbor exception is a good faith defense that you can use. And as long as you do these three steps, you can shield yourself from liability. So under statutes, I mentioned that. So I have a copy of the DMCA, and it goes on to talk about the trademark laws online. Again, I did that. Another where place I used that was the obscene material and obscene language, 1464. I posed that question on how you defend against one of those violations, and basically how you defend against these is you ensure that you don't have false or misleading information, nudity, profane language, indecent subject matter. Um, do your market research. Make sure that your ad isn't the most risque ad on being aired right now, and look at ads that had been banned or fined for violating the FCC, and say, is my ad, does it come close to this ad? If it does, probably tone it down a little, scale it back, and make sure you just try to be as tasteful as possible. Otherwise, you could be facing very hefty fines, and those are very costly mistakes. Um, so I included some of the other statutes that I mentioned in the in some of the case law. And then I tried to break them down. So this is the deceptive act. The advertisement in question must have been deceptive, unfair methods, unfair methods of competition, and then I included links to what that meant. The deception or unfairness must concern a fact material to the addressee of the advertisement, and the public interest must require the action. So, and I got that from that treatise that I mentioned earlier. And this was an extremely long law. I mean, it was many pages, and it broke it down and said these three things apply to this. And if you have these three things, that's when you'll have a deceptive, a deceptive ad violation. Again, with the alcohol, it says the Federal Alcohol Administrative Act, 27 U.S. Code sections 201 through 219A, and those are the ones that crack down on what type of advertising you can do with alcohol. Another really easy one, in short, is whoever utters an obscene or indecent. And this is literally the only language of this law. 18 U.S. 1464. Whoever utters an obscene, indecent, or profane language by means of radio communication shall be fined under this title or imprisoned not more than 2 years or both. So um, those were important regulations that I mentioned in the guide. This one I thought was really funny. I called it Obama's greatest achievement in office. It was about the Calm Act, and you can check it out for yourself right now.
When I'm watching the game, I don't want those ads coming all out. I don't want it to pick up the clicker. This is practical. Makes a difference right away.
If we're counting, what is the last
And look at this. This is all this.
one page bill?
One page bill. That's what I'm saying.
The Senate did turn it into almost
It,
two pages.
we do run on this. We do run on this. That's fine.
So that was so the Calm Act, and I liked how those people looked, very proud of themselves. That's great. The Calm Act, basically what it says, and this is the entire act. He wasn't, this. What is the synopsis? To regulate the volume of audio on commercials. So it is so short. I thought it was almost comical. I wanted to include the text of the act. So this is the entire act. That's it. That's the entire thing. And basically, what it says is that commercials, especially late at night, I actually noticed this myself. Sometimes, the content, you'll be watching something on Nat Geo, or some, it'll be kind of like a quiet broadcasting show or something, and then these commercials come on. Hey, come buy this product. And what? So they were, and so the commercials were way louder than the broadcast. It's almost to the point where it's jarring. So they passed legislation saying, "Hey, you can't do that. That's crazy." Although, and practically, how this has worked out is that the marketers have figured out that they have basically used quieter points in the commercial, and they get to use an average decibel volume to measure how loud the commercial is. So they still are really loud at the beginning, and then they get quieter throughout they quiet down throughout the rest of the advertisement, um, and then they get to use the average decibel, which is a lot quieter, but it kind of missed the point of it was to stop that jarring initial part of the advertisement, which they've kind of got around, unfortunately. And then I include the legislative history of some of these acts, the DMCA, the Calm Act. That one's really funny because the the legislative history is like 10 times longer than the actual bill. Um, the Lanham Act, that's the Deceptive Advertising Act. Finally, we go to our almost finally we get to the administrative law regulations. So I thought it was interesting how many different agencies, and you can see this to the left, that regulate advertising. There's the Federal Communications Commission. There's the Consumer Financial Protection Bureau. That's actually pretty new. Um, it was started by I think Massachusetts Senator Elizabeth Warren, who you know there's a lot of controversy around that. Anyways, United States Postal Inspectors, econsumer.gov. This is a website that the government created about advertising and foreign companies. United States Department of Agriculture. There's also another inside of the USDA's the Food Safety and Inspection Service, and they check up and make sure that the advertising on food products is accurate. The Internet Crime Complaint Center is another great place, and they regulate especially fraud and stuff like that. USDA, and this is another USDA one, the National Organic Program. So when advertisers say, my, you know, these, potato chips are organic, these people get in there and they, crunch up the chips and analyze them, make sure that they actually are organic. Um, Another one is the Office of the Comptroller of Currency, and they make sure that they they regulate uh, like banks, so banking commercials and lenders and stuff like that. A lot of times they also crack down on the OCC. You see them in like stock market or portfolio type of advertisements. That they make sure that they follow the rules as far as that. The FTC, we mentioned them, Federal Trade Commission. They make sure that they do a lot, deceptive ads and such. Let's see the tobacco, alcohol, tobacco, and firearms ATF. They they do like the tobacco, the firearm. Well, they do all that. The alcohol, the tobacco, and the firearm advertising. You're limited. That's another one. I didn't even include that. I didn't even think about that. But guns, you don't see guns um, advertised, too much on TV or anything like that. So I'm sure there's regulations pertaining to guns. I'd like to look more into that. The Department of the Interior, the National Credit Union Administration, again, that's about banking law, banking commercials. The SEC, they also, protect investors. FDA, and then of course the Department of Justice. So, and then on the right side we have the FCC standards, and this kind of breaks down what the FCC standards are. Uh, the FCC standards are delegated by Congress, and they have and they're included in the United States Code. Uh, and the FCC, the FTC, they all um, and they all operate under the powers given to them by Congress. So, and then this shows where you can go to get the FCC rules sections. And I thought this was interesting. They list them under the government printing office, which we talked about in class again. Um, and then you can find them in the Code of Federal Regulations, the CFR, and the government printing office prints them out. Can you say that on TV? Broadcasters aren't sure. I thought this was a good article from the New York Times, um, and it says basically, and this is kind of ties back to the George Carlin bit about everyone thinks that there's like this list of words that the FCC has that you're not allowed to say on TV, but that's not true. And I wrote a little article, a little tidbit after this. After pouring through the FCC website and the federal regulations issued by the FCC, it's obvious that the FCC does not have a list of words that are not permitted, much to the disappointment of George Carlin fans. Rather, if such a list was composed, it would likely include hundreds of unacceptable words and phrases that would warrant an actionable complaint by the FCC. Marketers and broadcasters alike must govern themselves in many ways, while the only indicators demarcating limits of acceptability are examples from case law. In that way, there's a pixelated, blurred line. It's kind of a play on this, censorship. But what is, so there's this blurred line separating what is acceptable and what is not. The closer advertisers and broadcasters get to that hazy line, the greater the likelihood they will have to answer and defend a complaint or fine issued by the FCC. And this is where I go on. This is what I kind of realized, and I thought it was kind of an interesting point. Advertisers are what fuel the standards of acceptability in broadcasting. However, when advertisements shock or offend the public, then it is broadcasters who must pay the price. So if the advertiser has an extreme ad, most of the time the broadcasters will have to pay the fine. So in that way, our system here in America is really set up as a quasi check and balances scheme. If broadcasters offend the public, that is, if the show that's being viewed does something, offensive, then advertisers break ties and withdraw their financial backing of the network. And similarly, if the advertisers put forth indecent or obscene advertisements, the broadcasters are liable for a violation of FCC regulations and federal law. So, in that way, the advertisers keep the broadcasters honest, and they don't want offensive material. They don't want to, finance and promote broadcasts that are obscene or offensive to people. In a similar way, the broadcasts have a financial incentive, to make sure that the advertisements they run on their shows comply with the laws as well. So, the it's kind of an interesting way that was set up and how it works, but it seems to work pretty well because when they have a financial interest, not to violate the rules, it's a good thing, and it takes care of, it helps the law function the way it's supposed to. And finally, the last step was defense and solutions, and we talked about a lot of these things, how to avoid television. The last two things I'll mention is disclaimers. So I always thought disclaimers were like required by law, but no, when I thought about it more, um, it made sense. The disclaimers are actually to protect the person making the advertisements. And what do? They disclaim warranties. So these are ways that people can um, protect themselves from liability down the road. The FTC generally regulates what disclaimers can be, and they need to be clear. They need to be unobstructed, easily readable, understandable. So when voiceover comes on and starts talking about, at the end of the commercial, in that super fast speech, some of those might not actually be valid warranties if they go too fast. So, and the same with the small print, in advertising, broadcast advertising, or even print advertising. So the disclaimers, while they are a tool to shield liability, they have to be executed properly. And then finally, the last solution that I would have for advertisers is there's liability insurance. And I got this also from that treatise. Advertisers may attempt to protect themselves from unforeseen liability arising out of an advertising transaction by purchasing comprehensive general liability insurance. And excuse me. And this is another great way for advertisers to protect themselves, and especially if they do have a product that is a little more scandalous or risque, if they sell lingerie, or erectile dysfunction pills or something, something like that, which people want lingerie, or swimsuits, or something like that. But they also want, so you have to, you have to market it on the one hand. The other hand, you don't want to offend, but some people may be offended even if you do it tastefully. So by having the liability insurance, you may protect yourself from the almost inevitable happening. It might be inevitable that litigation is going to be filed against you, and if you can just accept that as a cost of doing business, then the liability insurance might be a great way to go for advertisers, marketers, companies that have products that are um, maybe not as acceptable to uh, every group, in society. So that was my lib guide. Uh, I, like I said, it's not the there's a lot of things about advertising law that I didn't touch on, that I discovered throughout the course of my research, and I just kind of had to realize that I wasn't going to be able to do everything, and that this area of law is just vast. I don't even know if you could write a book, even a treatise, or even have a website about all of advertising law. It's such a huge area of the law, and it touches on so many different components and different subject matters of the law, and it's I thought it was a very interesting subject. So but this is a good place for someone to turn to start to get the answers if they are having an issue with, some sort of issue pertaining to their violation or something like that with an advertisement that they put out. So that was my goal, and I hope you enjoyed looking at my lib guide. Thanks.